Banks could soon lose their powers to repossess and sell loan collateral used to secure loans, such as cars and land, where the logbook or title deed was used as a loan security, if a petition before the courts succeeds. A petitioner has moved to the courts to require banks to obtain a court order before selling properties used as loan collateral. Now, Kenya's commercial banks are opposed to this petition, and the arguments presented by the Kenya Bankers Association, KBA, are as follows. Number one, the relationship between the lender and the borrower is contractual, so the bankers argue that the responsibilities and consequences of putting up your logbook and title deed are well understood prior to signing the loan agreement. Number two, that there is no obligation for the borrower to take up that secured loan or for a lender to provide it, and that is why the bankers are arguing that they should not go to court before repossessing your property. Number three, the bankers argue that the statutes are already there providing for how this process is handled, including the need for borrowers to take independent legal advice before signing on a loan agreement. Number four, the bankers argue that borrowers know the consequences of default, and there is indeed statutes already that are provided for how this collateral is recovered. And number five, the bankers argue that court involvement interferes with freedom of choice. Now, here the petitioner's argument. One, that selling properties without court validation is unjust, especially when the amount due is questionable. Number two, the process of court alienation, the petitioner argues, should involve a court decree. And number three, the provisions granting lenders statutory power over the sale without court validation should be declared null and void. The petitioner's lawyer also submitted that the right to property ownership is fundamental and cannot be taken away without legal invocation. Number two, the petitioner's lawyer argues that disputes between borrower and lender should be resolved by the courts, not within the banking institutions. And number three, that banks acting as judges in their own courts violates constitutional rights. The petitioner is requesting, number one, that the court declares that lenders must obtain a court decree before selling security. Number two, that disputes between borrowers and lenders should be resolved in court. And number three, banks shouldn't act as courts of law. The judgment on this petition is to be delivered on May 2nd, 2024. What are your thoughts? Should banks be required to seek a court order before repossessing the property submitted by a borrower as a security for a loan? Leave us your comments below this video.